The next session is about the BEAM projects on eutrophication and the laws of the Baltic Sea. And this has been, from the perspective of the Environmental Law and Policy Center and the Department of Law, a very interesting project. Thanks to the work, not least by Ragnar initially, when we made the application for BEAM funding, we were able to get funding to the university to deal with these issues from several perspectives, and not least from the law and governance perspective, some of which you have heard already earlier. Henrik has also been much involved in this. But it made it possible for the law department to work in a way where I think that natural scientists are much more used to than lawyers, namely to have several parallel projects looking at a related issue or an issue from different perspectives at the same time. And this one was about eutrophication and the legal structures and frameworks surrounding it in the Baltic Sea. So there were, you can say, 3 different kind of projects within BEAM on this issue, and they will now make their presentation. The first one is on international and EU law in the Baltic Sea, and that is Brita Bohman, who will start with her presentation, which is part of her work on her doctoral thesis, looking at it in particular on the international and EU level, that is, including the Baltic Sea Action Plan. In addition to that, we were glad to be able to engage Annika Nilsson to do a postdoc and to set up a research group dealing with comparative aspects, national aspects on this, and she will present it more in the details later on. And it involves not only Swedish law, but also Danish, Polish, and Estonian law. Again, rather different perspective from the one that Brita had. And then finally, we launched a project, a 1-year project for Katakmala, to consider whether there are legal obstacles or legal possibilities to create some kind of emission trading system for nutrients, drawing, of course, on experiences from emission rights in carbon dioxide. So I'm really glad that we will have this session where we will hear all these presentations, and it will be we will have a coffee break sometimes in the middle, I think before Katak makes his presentation. And then we will have also here an opportunity to have a panel discussion, comments from the different participants, and also questions and comments from the... I don't want to refer to you as audience. I think you're participants rather than an audience, of course. So, but from the floor, so to say. So the first one, please, Brita. The podium is yours. The title is Prerequisites and Potential Obstacles to Effective Legal Governance in the Baltic Sea Area.
Thank you. Is this working?
Does it? Does it? I think it does, yep.
And you can hear me? Perfect. Okay. So it's very exciting to be here and to have listened to all these very interesting presentations today. I can just conclude that I will kind of scrape over a lot of what has already been said. The overarching theme for... Maybe I should present myself first. My name is Brita Bohman, and I'm a doctoral candidate in environmental law here at Stockholm University. The overarching theme for my presentation in the program is international and EU law in the Baltic Sea as a basis for social-ecological resilience, which is also close to the topic of my thesis that I'm doing within the BEAM project. But the more limited presentation for today is then prerequisites and potential obstacles to effective legal governance in the Baltic Sea area. And I call it legal governance, which I compare to governance from a regulatory perspective. But before I go into some of my results then on these prerequisites and potential obstacles, I'd like to put my topic kind of into a context which will, for this audience, I realized during the day, be very basic. But I think also it's important because it puts also my topic and my study in relation to the national studies that will be presented after my presentation. And so the context then, why assessing international and EU law? And I think it's two main factors that are very important to keep in mind when it comes to this. The first one is that national laws, to a large extent, are today based on international and EU law, and this is definitely true generally within the environmental law, and as we've heard today, it's also very much the case when it comes to marine governance in Europe and in Sweden or the Baltic Sea area. So the prerequisites that we are provided for in international or transnational level of regulation is also providing a basis for the national implementation and what we can accomplish at the national level of regulation. The second factor is very basic, but might need to be said as well. It's due to the problem itself. If we have a complex international problem, we need transboundary or international solutions. So to come close to a solution to this problem, we have to cooperate, and of course then it's very important what we incorporate into these agreements that we make in trying to solve the problem. The next thing that I want to present also before going to results is, of course, trying to narrow down what I mean with effective legal governance. And my basic points of view here are then related to social-ecological resilience and ecosystem-based management, of course. I base my study on this assumption that environmental regulatory instruments must be fitted to contribute to social-ecological resilience through, inter alia, then ecosystem-based management at different levels and scales, and that there must also be an effective system for enforcement. And when I've studied this, especially the resilience framework, I've come to find a number of criteria or features that define ecosystem-based management, which are also, I should say, reflected in what is the concept of ecosystem approach, which we've also heard being mentioned today, which is a concept adopted both within HELCOM and the EU, and that should be reflected in these legal regulations. And some of these important criteria are adaptability, flexibility, as well as taking different spatial and temporal scales into account. In my overall study, in my thesis, I have narrowed down a large number of criteria, but today I will only focus on adaptability and flexibility. And just for clarity then, I want to also state that I understand adaptability as slow processes of updating measures or methods in relation to new knowledge and other such changes that are relevant for management, and that flexibility is a faster process of responding to or adjusting measures and methods to more spontaneous and unpredictable changes. So based on this, some of the results that I found regarding prerequisites for effective legal governance is that the regulations that I've investigated, which are then the Helsinki Convention, the Baltic Sea Action Plan, the Marine Strategy Directive, and the Water Directive, primarily. I mean, the Water Framework Directive, as I assume most of you know, is connected to a large number of other different directives and regulations, but that are incorporated into the Water Directive. And they do, to a large extent, include prerequisites for ecosystem-based management. They do this both in their general structures as well as in more specific mechanisms. If we look at international law, for example, it's very flexible in the way that provisions are usually quite vaguely formulated, and states have a large margin of discretion in choosing how to implement them. They're also usually adaptive through having mechanisms for adapting the provisions through, for example, adding protocol, or in the case of the Helsinki Convention through adding annexes and recommendations that provide an update to the general provisions of the Convention. But the more signifying then for the Baltic Sea when it comes to this is, of course, this overlapping regime that we have with flexible and goal-oriented frameworks, which are then mainly created through the Marine Directive together with the Baltic Sea Action Plan and the Water Framework Directive. Sorry. And this is, as we've heard, their goal is to accomplish good environmental status through programs of measures where the states have a large margin for deciding on what measures that they deem appropriate in accordance to reach good environmental status. And this provides a system where we can have a diversity of measures through this program of measures adjusted to different temporal and spatial scales and multi-level regimes. And what more is a very complex situation that is specific for the Baltic Sea area is also the interaction between EU and international law in this area, where these different regimes are interacting and indirectly strengthening each other. EU has had a very important role in kind of forcing HELCOM to adopt new legislation, primarily the Baltic Sea Action Plan. And the Baltic Sea Action Plan, with its principle agreed reduction targets, kind of take this further. So they have a very important and exciting interaction in this overlapping and dynamic regime. So I see a lot of potential or prerequisites for ecosystem-based management here. What could be obstacles, however, can be also detected in connection to this complexity that is created by this multi-level regime. The flexibility and the overlapping scopes in this regulatory situation makes assuring compliance difficult, or at least complex. For one reason, which is strictly judicial then, is the fact of this interaction between EU law and international law, where we might not have a final, might not say exactly how a court would deem this, but seeing these reduction targets within the HELCOM regime together with the kind of far-going goals within the EU regime might interact and affect how we should interpret these requirements. But it's complex and it's difficult to say exactly how what this actually implies in the end. And I would like to say that this is also a potential asset in this regard, since it might mean that this more strict compliance regime within the EU could enforce the requirements that are connected to the Baltic Sea Action Plan. The other aspect of this is the flexible nature of regulation, where space for states to deem the measures to be implemented becomes an obstacle to effective compliance control, because it becomes difficult to assess the limit of compliance and what is actually required. And this is, of course, also connected to the diffuse nature of the problem. And in the end to this, I want to add that HELCOM has also confirmed here that the general level of what's been reported so far in the national implementation plans under the Baltic Sea Action Plan has showed a quite low level of ambitions by the states, which might be then due to this flexibility left to the states in implementation. I want to add just to the first point that I mentioned, the stricter compliance by the EU, since we've already heard also Henrik say earlier today that the compliance mechanism within HELCOM is generally not so strict and has a number of deficiencies. So to my final slide, which I've chosen to call conclusions ? We can just conclude that there are both prerequisites and few potential obstacles to be found. But I want to add to this that this is just a brief presentation of a few aspects of a very complex issue, and that more perspectives have to be added for the full picture. And we also need to remember that these legal instruments are rather new and that the process of implementation is still ongoing. And since this is an adaptive structure, it means that the fishes that we've seen so far will be adapted in the new cycle of implementation. So thank you for listening.
So thanks a lot, Brita. What I think there was addressed here, which was also touched upon in the morning, is the changing structure of the legal norms. It's not only to say that this is prohibited, this is permitted, or this level must be achieved, but it's a system of legal approaches which are more process-oriented. Of course, that is very challenging for this kind of assessment that Brita just mentioned. Another, I would say, advantage or positive effect of BEAM project has been the opportunity to engage not only with colleagues from other universities. We have always had good relations with Uppsala, Lund, Gothenburg, Örebro, Umeå, Luleå, and other universities in Sweden. And Annika is a good example of that. She wrote her PhD in Uppsala, and shortly after we were able to bring her to Stockholm for a postdoc for a bit more than 2 years. But then she moved back to Uppsala, where she had now her position as a lecturer. But we managed to bring her here again every now and then, and I'm very glad to that. But we also were able to engage lawyers from around the Baltic Sea. And we have had in the Nordic countries for many years. Helle and I think we started as PhD students. We don't say when it was, but it was long ago. So we had an established network in the Nordic countries. But it has been difficult to engage also with colleagues in the Baltic region and in Poland. So this was, in that respect, a great opportunity. Annika will say more about that. She will first start with a short presentation, and then she will go down, rest for a while, listen to the others, and then she will come back. But you can explain that. Please, Annika.
Yes, can you hear me? Yeah, okay. Well, thank you. My contribution today is, I would say, comprehensive and combined approach, coordinated with a coordinating task, very ecosystem approach to this project. I will present some fundamentals of this project, and then we will hear from national reports, and in the end I will make some presentation or discussion of comparative results regarding ecosystem-based regulatory management on the national level. And this very much connects to what Ida talked about in the first session about the second step, about actually bringing the ecosystem approach into action in decision making. So, we have heard from Brita here today that management and control of eutrophication is a common task in the Baltic Sea, and therefore transnational cooperation is needed. There are also a lot of legal agreements in place, and we have common objectives. But when you start reading up on the results, they are rather marginal. So it is interesting in that perspective to start looking at what actually is done to implement, to realize these common objectives. And that is very much done on the national level. One interesting feature, then a central feature of these transnational agreements is the ecosystem approach. So in this project, I have ventured to compare national regulatory approaches and how they realize ecological objectives. So it is a critical analysis of ecosystem approach in law, trying to introduce the question of what does ecosystem approach mean in law. As we heard today also, I will kind of repeat very shortly, is that international law has established the ecosystem approach. But it is to some extent unclear to lawyers at least, what does this mean within law? And we have discussed and tried to look at, in our research at the faculty, some features of this. We have heard about adaptability and flexibility, but there are also a lot of other features at the multi-level and multi-stakeholder approach, diversity of methods and action, coordination, integration, and so on. But I want to also show that compliance control is also central in an ecosystems approach, to try to assess if we reach these common objectives. And when it comes to compliance control, the lawyers will of course start thinking about, well, we recognize this from law. It means a little different thing when you start discussing ecosystem theory in general and in law. But in a legal study, of course, we take on the approach or the point of departure that central for law and for legal management approaches is its ability to have the authoritative statement, to actually say that this is the norm, this is what you must achieve, and to control compliance. But also to set up structures to kind of delegate different responsibilities and duties with different actors, not least public institutions. And that is actually, we have used this kind of idea of what ecosystem approach entails and try to then analyze or look at national laws and to try to find out, is there an ecosystem approach within law? Can it be realized through the national laws? Well, the research method then in this comparative project is that after having set out these questions about eutrophication and what ecosystem approach means, we involved these colleagues in the different countries, in Denmark, Estonia, Poland, and Sweden, to draw up country reports describing the national laws regulating especially wastewater treatment and agriculture, which are then main sources of water pollution, of nutrient pollutions to water. And also to look at the water management system. And this study was made on a common template with common questions. And these questions were also kind of trying to guide the researchers to observe different features of ecosystem approach in their laws. And I will only show you some examples to give you an idea of how these questions were formulated in this template that we used in the project. For example, how are ecological standards reflected in the regulation of whatever was treated in that chapter? How are such ecological standards implemented and enforced? Are stakeholders involved in regulation? What happens if poor ecological status is detected? Describe the processes and instruments. Can stakeholders trigger such processes? And so on. To try to identify features of ecosystem approach in these national regulations. So with that, these examples then, we try to make these reports. And I want to just note to you that these reports are, available on the website of Stockholm University, on the link provided in the slide. So, And with that introduction just to our project, I would like to invite our national researchers to present the reports. Jonas?
If you want to do it, you can do it. Shall I? Okay, I will do that. Well, thank you very much, Annika, for this presentation. So here is the top team. And we will have the presentations in, I think in this, not really in this order, but we will start off with Helle Anker, who is, as I said, an old colleague, not only a prominent scholar from Denmark, but she has also been a key person in maintaining the Nordic network over the years of environmental lawyers. I'm very glad to have you here. She will present the Danish report, and then I will present the other guys later on. Please, Helen. You will have some help with the presentation.
Thank you very much. Can you hear me? Is it on?
Yes.
Yes. Good. Let's see if we can find it. Did you put it here? Okay. Well, thank you for the invitation, and also for the invitation to contribute to the comparative study. I think it has been very interesting, or it is very interesting to do these kind of comparative studies, although always a challenge. So I'll present some of the results, if you could say that, from the Danish report that was made together with my colleague Lasse Bohman. And I'll also present some more recent developments in Denmark as regards nutrient emissions. Okay, so regulating nutrient emissions in Denmark, well, that has been known for quite some time, and we have had what we call aquatic action plans in place since 1985. And why 1985? Well, 1985 was apparently a year where there was a lot of oxygen depletion in Danish waters, and there was in particular somebody that is an oxygen depletion that affected lobsters. So we had television broadcasting dead lobsters from Kattegat. And after that there was political initiatives. So we have had that then continuing through these aquatic action plans that I'll tell you a little bit more about. And then we of course also have the implementation of the Water Framework Directive. And some of you may also ask, do we also implement the Marine Strategy Framework Directive in Denmark? Yes, we do. But actually everything that is related to nutrient emissions, land-based nutrient emissions, is primarily governed under the implementation of the Water Framework Directive. So it's unlikely that anything more will happen under the Marine Strategy Framework Directive when it comes to regulating land-based nutrient emissions. So I'll just try to give you the overall picture of this regulation, and then look into whether does this regulation express an ecosystem approach. And I think there are three sort of important distinctions between different policy measures, types of policy measures. We have the general regulation and standards, for example, on it could be emission limits that apply to all types of different activity. It could be wastewater plants, or it could be agriculture. We also regulate through individual permits for farms or for wastewater treatment plants. And then we also have a category that I call active management. That is, when we really have a problem, we need to, for example, restore wetlands. That could be this kind of active or proactive management. And I think it's important to distinguish between these policy measures, also when you look at to what extent they are able to accommodate or express an ecosystem-based management. And then finally, I hope we had the time to just go into a proposal for a new regulation of agricultural emissions in Denmark, which is currently being prepared. The aquatic action plans, as mentioned, we have had them since 1985. In principle, or basically, they are political agreements. So they sort of require a majority in parliament. They have sort of two elements. One is the setting of national reduction targets. The other one is the identification of the relevant policy measures to achieve these reduction targets. And we've had the reduction targets of 49% reduction of nitrogen emissions since 1987, and 9% phosphorus reduction as regards agricultural emissions. That was actually achieved in 2003, but then we didn't see the expected results. So what do we have to do? We have to reduce further. So there is a further target of 13% reduction of nitrogen and a 50% reduction of phosphorus from agricultural emissions. Well, unfortunately, we haven't been very good at achieving these additional targets. Nevertheless, in 2009, also as part of the implementation of the Water Framework Directive, an additional reduction target was set. This time not in percentage, but in tons of nitrogen. Actually, the 2009 plan was not called an Aquatic Action Plan, it was called a Green Growth Plan. For sewage, the reduction targets has been a 50% nitrogen reduction and an 80% phosphorus reductions was a target in the 1987 Aquatic Action Plan, and that was actually achieved in the mid-90s. So we have had no further sort of reduction targets as regards sewage. The policy measures for agricultural emissions, the policy measures has primarily been general regulation. So general standards applying for all farmers, applying in particularly norm systems for nitrogen, livestock balance requirements, and fertilizer accounts. It has also been general requirements for catch crops. That's for, like, there should be catch crops for 10 to 14% of your land. And an additional requirement of further 140,000 hectares of catch crops was part of the 2009 agreement. We also, in 2009 agreement on green growth, introduced 10-meter cultivation-free buffer zones along all watercourses and all lakes. And in this case, a lake is everything which is more than 100 square meters. For sewage, we also have the individual permits for livestock installation as a policy measure, active management restoration of wetlands. For sewage, the primary policy measures has been wastewater plants, laying down the infrastructure for wastewater facilities, the requirements to connect to wastewater facilities, permits for wastewater treatment, and environmental quality standards and best available technology. So what has happened? For agricultural nitrogen emissions, well, we reached actually the 50% reduction around 2003. This was from a level of 311,000 tons nitrogen per year to about 162 tons of nitrogen per year from agricultural emissions. This has led to an improvement of environmental quality of watercourses. But if we look at the coastal environment, it's a little bit less positive. It is really difficult to see the improvements in environmental quality of coastal environments or coastal waters. And why is that so? Well, some say that there's an enormous time lag for introducing all these measures and then for actually seeing the improvement in the aquatic environment. Or perhaps we have other sources than the land-based agricultural sources from Denmark. For sewage emissions, you can actually see that we quite quickly achieved the reduction targets. For nitrogen, it was 50%. For phosphorus, it was 90%. So how does the water management system look when we talk about the implementation of the Water Framework Directive in Denmark? Well, some might say it doesn't look too good. We have had to change our system. And actually, the old system, we have not been able to adopt our first river basin management plans in Denmark yet. The deadline in the Water Framework Directive was 2009, December 2009. Well, actually, we had an adoption of the first generation plans in 2011, but they were declared invalid in 2012 because there was appeals to the Administrative Appeals Board based on the argument that the consultation period had been too short. And actually the consultation period was related to changes in the plan, and there was a consultation period of 8 days, which clearly the board said that was too little, so then they declared these plans invalid. But we had a system, and then after that the ministry changed, or the parliament changed the system. We had a system where we had river basin management plans with legally binding objectives and measures. There was a clear focus on supplementary measures dealing with agricultural nitrogen and phosphorus pollution in particular. We had the public participation and administrative appeals. What has happened after they were declared invalid? Well, we had a change. So now the river basin management plan will be only informative documents. We will instead have statutory orders on environmental objectives and statutory orders on the necessary measures. And for these statutory orders, there will be no appeals. We can appeal the river basin management plan, but maybe that's not what we're really interested in. And also there has been some doubt now, or there is some doubt about the environmental objectives, whether they will be legally binding or not. As it is formulated, only the statutory orders on the measures will be binding. So, this is the implementation of the Water Framework Directive. And as mentioned, the Marine Strategy Directive, when it comes to nutrient emissions from land-based sources, we primarily rely on the measures in the river basin management plans. Does this regulation we have in Denmark, does it express an ecosystem-based approach? Well, the starting point, the river basin management plan and the maritime or marine strategies, they are the starting point, laying down the ecological status, the relevant objectives. The question, I think, and the most important thing is what kind of measures, how do we link the measures to the ecological status and the objectives? Is the nutrient-like regulation that we have linked to the status and objectives of the ecological systems? Does it reflect an adaptiveness that we adjust the measures along the way as we get more knowledge about the ecological status and the objectives that we want to achieve? Is it sufficiently flexible to allow for such adjustments? You could also discuss the stakeholder involvement. I'll not go into that, but more look at the adaptiveness and the flexibility. If we look at the agricultural emissions, we have the general nutrient regulations standards, the nitrogen norms for farms, fertilizer use, etc. Well, they are to some extent adapted as they are linked to the overall reduction targets. We need to do something, so we regulate. But is this really an ecosystem-based management approach that matters a lot? They're not linked to the specific ecological systems. There are some adaptive elements in setting the nitrogen forecasts and norms, soil types, climatic conditions, etc. But still they are not linked to the ecological systems or the ecological status of different water bodies. We have the individual permits for livestock installations. Well, they are actually differentiated, have differentiated conditions for manure load in sensitive areas. So if you have a farm where you have your farmland in a sensitive area, you are likely to be subject to much stricter conditions than a farm in another area. We also have the active management, the restoration of wetlands, which is also targeted towards sensitive areas. This is, as far as I understand, ecosystem-based or adaptive approaches, something that reflects an ecosystem-based management. For sewage, We have permits that are linked to general environmental quality standards and environmental objectives, but we also have a zoning system for private sewers in rural areas, which is zoned three different zones zoned according to sensitivity in different areas. So this is also an example of an adaptive or ecosystem-based approach. This map shows particularly nitrate-sensitive areas in Denmark. There are 3 colors. Dark green colors are the most sensitive areas. This map is used when we give permits, the individual permits for livestock installations. Then this map is used to differentiate the conditions. So in the dark green areas, farmers will only be allowed to, or they will have a reduction of 50% compared to the general 170 kilo N per hectare. So there will be a 50% reduction. Well, is this ecosystem-based management? Well, yes, but is it effective? Well, not so effective. Because maybe there are not that many livestock farms in this area. So what would then be effective? Well, the effective system would be if we can differentiate the general standards according to the sensitivity of the area. Because then we would target not only livestock farms and manure spreading, but we would target all fertilizer spreading on all lands. And this is the new proposal, which was made by Natur- og Landbrugskommissionen, the Nature and Agricultural Commission, where we differentiate, or the proposal is to differentiate nitrogen norms depending on the capacity of the land to retain nitrogen and the sensitivity. Most of these areas are Natura 2000 areas. We provide flexibility for farmers at farm level to adopt crop rotation or catch crops or whatever to compensate for possible reduced norms. We can also use targeted active management, that we need to identify the most sensitive areas. Perhaps there should be no farming in these areas, and we can perhaps then achieve a high level or a more effective nutrient regulation. But all this needs to be linked to the river basin management plans, or it could be the marine strategies, to create an ecosystem-based approach. That is where we have the knowledge about the status of ecosystems, we have set the objectives, and then we need to link this knowledge and objectives to the measures that we use to regulate these different activities. So it's not enough just to make nice plans. And sometimes it's a problem with the plans, as we have experienced these problems with the plans in Denmark, the river basin management plans, that it may end up in procedures and quarreling about procedures. So we need to look at these linkages between the objectives and the measures. But then we also have faced some problems, because how much knowledge do we need to have this kind of regulation? And how do we deal with the distributional effects, that some farmers will suffer more than other farmers, and perhaps in some cases the restrictions will be so tight that it is also a matter of property rights. So that raises a lot of new legal issues and questions. Okay?
Thank you so much, Helle, for this presentation. And as we see now, we are moving from the very ground presentations, the more abstract, bringing it down to very concrete, specific issues on permits and on regulations. And this is really, I think, this link is really one of the key points in this project. Thanks a lot. The next presentation is by Maciej Nyka, who was very enthusiastic when asked to participate in this project. He is a Doctor of Law at Gdansk University, where he also teaches. Please let us learn from your presentation concerning Poland.
Thank you for the floor, Jonas. Good afternoon. I've been asked to present a short lecture about the Baltic Sea eutrophication problem from Polish perspective. As my first speakers, I just want to indicate that you all have access to the newly published ebook, where much more information is available. In Polish law, the environmental law is very dynamic, which of course means that we cannot speak about certainty of law, which is a disadvantage. But it means that if you want to refer to this ebook, please do it quickly, because the legal status of matters which are discussed there change. Well, unfortunately, I have to start with something which is very unpleasant to me. I want to show you the current state of play. Here we've got the total nitrogen and phosphorus loads to the Baltic Sea, and unfortunately I have to show you that Poland is responsible for 30% of nitrogen and 37% of phosphorus input, which makes me willing just to say sorry and get out of this place. But I hope you will allow me to continue. How can I explain this? Well, there is one way of explaining it, and it means that size unfortunately matters. Poland is a quite huge country with a lot of population. It has almost 45% of the population of the Baltic catchment area. It has 50% of the farmland in the Baltic Sea catchment area. And it is exclusively, because it's 99.9 or 0.8% connected with the Baltic catchment area with its rivers. So it is for Poland impossible to pollute other seas. We have to do this in the Baltic. I want to show you that we've got some nice trends. They show that we are improving, and this is always very good, especially for academics and for teachers to see the improvement. We are improving. Unfortunately, this is the last, the PLC 5.5, where the year 2010 is also included, and sorry, I cannot explain this to you. I think they changed the way in which the monitoring is taking place, and this can be the answer to this question: what happened? We, however, are really responsible for the change, because, as you can see, Poland was able to change the water input. As you can see, we have here the biggest in tons, in thousands of tons, reductions from all other Baltic states. Of course, we have to admit that we had a huge amount of nitrogen which we could limit. So this is why it looks like that. But as you can see, we are somewhere in the middle of the state if we look at the real reduction which have occurred since 1994. I just want to add some additional remark. We have to remember that Poland is a member of the European Union just since 2004. And it means that effective instrument which really influenced Polish attitude to the protection of the Baltic Sea. Of course, Poland is also a member of Helsinki Convention, but we have to admit that European law is much more much more effective in changing those digits. So I think those improvements show that we can be a little bit more optimistic than at the beginning. I also want to say that Poland is quite ambitious. As you can see, we agreed on the very ambitious amounts of reductions. At first, here we've got the reduction limit from the Baltic Sea Action Plan. The second is the reduction limit from which had been adopted in 2013. As you can see, Poland is quite ambitious. Here is a mistake. Yeah, it's 43,610 tons, and again, much more than any other of our partners. Of course, we will see if this dream will really come true. Of course, the Baltic Sea environmental protection from Polish perspective and from all other which already been and will be presented here consists of three dimensions: the international environmental law, mostly the Helsinki Convention, the European Union environmental law, and national environmental law. Those interrelations were already presented by Annika, and so I don't think that we have to go through them again. Let's look at the data. Well, sewage regulation in Poland, we of course, it is based on the Helcom regulation and on the Water Framework Directive. And we are experiencing huge problems in this area due to many reasons. Among others, we have to admit that historically speaking, our system of sewage treatment in Poland was dramatically underdeveloped, and it had to develop in a very quickly, just before accession to the European Union. Poland was able to negotiate the transitory periods for the implementation of Water Framework Directive. Those transitory periods, the last of them is ending now, so now we are in the general rules which stem from this legal act. The second problem, which appears, is the fact that, of course, Poland, we've got huge rural areas when the development of sewage treatment is also problematic because, of course, it has to be done individually, and those facilities are quite often in a very poor condition. Technically, it is almost impossible to verify their condition. So this is quite a problem. And of course, in rural areas, there is not insufficient collective sewage infrastructure, which I think this problem can be also identified in other countries. Well, I just want to mention one legal instrument in this area, which, in my opinion, really makes the change. It is something which we may be really proud of: the National Program of Communal Sewage Management, which is functioning for over 10 years already. And as you can see, the program has almost reached its forecast, so it is almost finished. It has identified lots of agglomerations. As you can see, it costed us 10 billion euro, which for a budget of Poland is, of course, a huge amount of money. But we have gained through this 31,000 of new sewage system. We have modified almost 3,000 lots of new sewage treatment plants were built. Even more have been modernized, and similar program is also functioning in the rural areas. I must say that it is estimated they are now finished in 98-99%. It is a little bit longer than we expected, but well, now they are fortunately finishing with them. And it is estimated that when they will be fully over, then 100% urban population and 60% of rural population will be connected to the sewage treatment system, which is quite a nice achievement, I would say. Is there the ecosystem approach to the regulation of sewage in Poland? Well, of course, some aspects of this approach can be seen, but of course, I have to admit that the observer have to be very have to focus a lot in order to see it. We've got, of course, the emission standards, which function apart from emission standards, which in some way reflect this ecosystem approach. We have similar as in Denmark treatment plants construction rules which regulate where they can be built in which technology. We've got limits of emissions in processed sewage water and obligatory reduction levels. We've got water monitorings, we've got water standards which depend on the function of water. We are more tolerant for water which won't be used for drinking water, and a little bit less for this. And what is, I think, very ecosystemic approach is the fact that the ability to function as an ecosystem is a standard of the surface water. It is two species of fishes, which we may say function as kind of identificator of the water standard. Is the system adaptive? Again, in theory, yes. I think it hasn't been mentioned here, but we should mention it, that if we want to speak about adaptiveness, we have to have a human resource, the administrate in the field of administrating them, that will be prepared to do this task. And I don't think, I have some doubts if we can say that if we are talking about the situation in Poland. We've got water permits, which of course are individually issued, which are short-term, usually 4 years, which are obligatory revised, and the clean water is, by the courses, is being recognized as a public interest, so which means that if this public interest is at stake, then the water permit can be easily withdrawn. Of course, another aspect of adaptiveness is the identification of sensitive areas. with which we have lots of problems. Poland was even sued to the European Court of Justice because we identified too few of those areas. I think there was 1.8% of the territory of Poland was identified as a sensitive area. After this, in 2 years ago, it has been changed to the 4.8. For the European Commission, it was sufficient, but I want to mention that there's a research made in, I think, Hamburg, which shown that in Poland we should speak about 30% or even more of the territory of Poland, which should be considered as a sensitive area. So this is something which needs attention. The second thing which I want to mention are the problem of agricultural production and the nutrients pollution which stems from this. And here we also got a lot of trouble. First of all, the structure of farms and farmlands. Polish law limits the land ownership, if you want to be considered a farmer, to only 300 hectares. If you produce on a bigger area, then you are subject to stricter rules and you are treated as an entrepreneur. The next thing is the low development of farm production. Huge areas which are used for this farm production, which already mentioned. Some technical underdevelopment, but this, thanks to the money from the Common Agricultural Policy, is not such a huge problem as it used to be. But paradoxically, the accession of Poland to the European Union and the access to the financial sources have also worked for a disadvantage of Poland, because if you can, I don't have those data with me, they are mentioned in the ebook, but Poland accessed in 2004. In 2005, there was a huge rise of the nutrients because the farmers were able to buy the artificial fertilizers. It is like that, and as you can see, wetlands, 13% of territory of Poland. So this is surely the area which potentially are very sensitive in this area. Yes, I know. I have to start finishing. I just want to mention that we've got different regulations for big farms, medium and farms and small farms, both in the field of rules which regulate fertilization and in the field of the rules which regulate the manure storage. There are, of course, some aspects of ecosystem approach and some aspects of adaptiveness. We've got the scientific research made on the soil, which is an element of issuing the fertilizing plants. But again, those things are usually obligatory to the big farm producers, not the small ones. I don't have time to continue, so I will have to just show you shortly the adaptiveness aspect and say thank you very much for your attention.
Thank you very much, Maciej, for showing this presentation and also for highlighting slightly different issues that were brought up from Denmark. We will continue directly with the next presentation, which is about Estonia and Estonia's approach to include, whether to include ecosystem-based management. And the presentation here will be made by Kaarel Relve, who is a lecturer at Tartu University. And you can explain also your colleagues who have been involved in this project.
Okay.
So, please, the floor is yours, Kaarel.
Just a second. No? In your pocket? Okay. As you wish. Good day, ladies and gentlemen. I'm Kaarel Relve, lecturer at the University of Tartu. Our university is the largest in Estonia, and it's also the oldest. It was established about 400 years ago by the famous Swedish king, Gustav Adolf II. So thank you, Swedes. I owe you my show. And I'm going today present the country study of Estonia, which doesn't mean that I actually wrote it. The team of authors you can see on the slide. The biggest contribution was made actually by Katrin, who is a doctoral candidate in our university, and because she has got married recently, the name has changed. And my colleague Hannes Veinla wrote an introductory part to this study, the first 2 chapters, and I did one part of the study, the one which pertains to water quality management. So I was thinking of starting by some general slides, but I think we have too little time, so I highlight only a few issues here. One of the things which has to be kept in mind when analyzing the legal framework from the viewpoint of ecosystem-based management is that you almost certainly will run into the issues of competence. The management, or based on the ecosystem approach, is the scope is so wide and it's also so complex that it's never going to be just the competence of one institution. So in this regard, I would like to point out that the primary responsibility for it lies with the Ministry of Environment, but because one of the biggest sources of pollution comes from agriculture, then the Ministry of Agriculture has the secondary role. And I will go into it later, but there are problems of coordinations which actually affect quite a lot the implementation of the Estonian regulation. The other aspect is that Estonia, although Estonia is a unitary state, we have about 200 local municipalities which have autonomy as regards certain local issues, such as spatial planning, which is relevant for the Marine Strategy Framework Directive, and also urban wastewater treatment. An issue there is slightly different. There are very big differences between the municipalities. Some of them are huge, like the capital city of Tallinn, which has 1/3 of the population, but most of the municipalities are very small, having only a couple of thousand of people. And these municipalities are just too small to effectively manage the water quality or the pollution in general on the basis of ecosystem-based approach. At least I think they have this problem. Now, a few slides about the pollution from Estonia. This is a historic slide. The data ends at 2007, but it just shows the dramatic change in the last 25 years. This change was mostly brought about by the collapse of the Soviet Union. And firstly, the pollution load decreased due to decline in production. Later, the decline can be attributed to renovation of waste treatment plant, modernization of production, but also more effective regulation. However, in recent years, I would say the trends are not so dramatic. If you take into account the climatic factors, then the waterborne pollution, which is the biggest part of the pollution load, is more or less the same. Well, and the question is whether the law is sufficient to have a further reduction in this pollution. But let me now continue with things that I'm a little bit more familiar with, with this law, and just a few remarks, general remarks about the Estonian system. Estonia is based on the continental system of codification, which means, in layman terms, that court decisions are not sources of law, at least theoretically they are not. We have very strong German influence. For instance, the administrative law in general is closely modeled after the German law, which doesn't mean that this is the copy of the German law. And like one example of it is the procedural aspects. Because Estonian constitution has the monist approach, which means that sufficiently precise international norms that are contained in treaties that are ratified by the parliament. These sufficiently precise norms can be applied directly. Then, for instance, Aarhus Convention has had quite a big impact on the procedural issues, like issues of standing. Courts have numerous times relied directly on the convention in order to widen standing. And in general, Estonian environmental law is very generous to environmental rights, participatory rights, and also the standing rules. If I had to generalize about the Estonian environmental law, then I would say that it's mostly driven by the developments in EU law. Most of the Estonian environmental acts consists of requirements of the directives which have transposed into Estonian law. The problem is that if you get into the ambitious directives, like water framework directives, then this Estonian approach is not really sufficient. If you look at the provisions which transpose the water framework directive, then they are sufficiently precise to avoid the infringement procedure. The infringement procedure is the procedure where the European Commission takes a member state to a court for not transposing the requirements of the directive. They are sufficiently precise to escape the notice of Commission, but typically not sufficiently precise to actually allow effective implementation of this directive. And as an example, you might know there is a very nice idea in the Water Framework Directive, Article 10, which is the combined approach, which says, for instance, that you have to take into account both source pollution, point source pollution, and also diffuse pollution in taking decisions. So you have to apply best environmental practices and so on and so forth. And the respective Estonian provision almost verbatim copies the requirement of the directive. But it mostly stays there. So the provision says, for instance, that if the environmental quality objectives have not been reached, then additional measures have to be taken. But it doesn't specify who will take the measures and what the measures will consist of. And as such, it's useless. You cannot really apply this. And there are many other examples. Also, general remark, Estonian environmental law, it tends to be sectorial. It means that it's fragmented. Often there are not sufficient cross-links between different areas of law, and which of course means that it's quite difficult to apply this ecosystem-based approach. However, there is hope, at least, for the change. Since 2008, Estonian environmental law has been codified. This year, the general part became applicable. It contains general objectives, general duties, general rights about the environment. And there are some parts of it which are relevant, like, for instance, the principle of high-level and integrated protection. But it only regulates, I would say, large issues, and most of the relevant regulation will be in the special part of the water. And this regulation has not yet reached the Parliament. The draft exists, but it's a little bit too early to speak about it, I think, because it may change quite significantly. But it means that also, as it was in case in Poland, if you want to rely on the study, do it quickly, because probably about in 1 year it would be obsolete in details, at least. So now some remarks about the different aspects of Estonian legal regulation. I will first talk about sewerage, then agriculture, and finally about water quality planning and management. Now, to make it quick, the Estonian system is, could be said, is based on permit. The water treatment facilities are required to have environmental permit, except when the threshold, the 5 cubic meters a day, is not met. In such cases, and also in cases of households, then general rules apply. And yes, so it's the general system of control. What are the problems and or positive aspects in regard to ecosystem-based approach? Firstly, the first issue I already discussed. This is that we have quite a few general provisions which are not really operable. Then one good example of the ecosystem approach is that, at least according to the law, the sewerage system has to be constructed on the basis of development plan, and this development plan has to be integrated with the water management plan. The problem is that in practice, many municipalities are too small. They actually don't even manage to draw up the development plan for the sewerage, not speaking of integrating it with the water management plan. So it's one example of how this institutional setup actually is hindering in having this ecosystem-based approach. Another example, the Water Act says that stricter emission limits can be applied or stipulated in the water permit if under certain conditions. For instance, 30% stricter emission limit values are applicable or can be applied if the status of the receiving water body is bad. The problem here is that the authorities do not want to rely on this provision very much. And because of the burden of proof, they have to show that this particular waste treatment facility is causing these problems in this receiving water body, which may not be easy at all. And also, this system doesn't really take into account long-term cumulative effects of pollution. And there are other aspects, but I will move forward. Agriculture. In general, the regulation on agriculture relies on one hand on best practices, which are not obligatory, at least not in direct sense. They are obligatory in some cases indirectly because they are preconditions for receiving financial aid. And on the other hand, the regulation on agriculture typically relies on generally applicable rules. For instance, there might be specific rules for storage of fertilizers and manure, or specific rules for operating in nitrate-sensitive areas. And only in exceptional cases there is a permit. There is a permit when this agricultural activity exceeds the thresholds in the Industrial Emission Act, which is more or less the equivalent of the Industrial Emissions Directive, and also if they exceed the specific, not agriculture specific criteria set out in the Water Act. Again, what are the problems? There are many issues because this is a huge area of law, but just I picked a few. The first, I think, the problem is the lack of coordination. That the Ministry of Environment, which is the primarily responsible ministry, cannot really impose its will on the Ministry of Agriculture. And it seems that in many cases the Ministry of Environment has focused on these aspects which are within this area of governance. For instance, there was a national state audit which looked at the measures taken in regard to one of the large lakes, Lake Peipus, and it turned out that quite a large proportion of these measures were aimed at the wastewater treatment facilities, the point source pollution, but not towards the diffuse agriculture pollution from agriculture, and there was really no explanation for that. Also, there's another example, the Environmental Inspectorate, which is an institution in the area of governance of the Ministry of Environment, typically does not inspect farms. They limit themselves quite a lot as regards the inspection. So, in essence, there is not much attention to there is a lack of coordination, in my opinion, and also lack of inspection and enforcement. And finally, the issue is, with agriculture is that there is the regulative framework or regulative system is really not flexible. If there is a problem, then often for instance, the environmental inspectorate does not become aware of the problem because the monitoring data is not immediately available. And even if they do become aware of the problem, or the authorities in general are aware of the problem, there is really not a very good means to regulate the issue. There is no permit. Lots of the requirements are in the form of recommendations, which cannot be enforced. And then you have the option of amending the generally applicable rules, but this is really not targeted to certain farms. So it's difficult to control the emissions according to our current regulatory framework. Now, the final aspect, the water quality. This is quite a complex issue. I won't go into the detail maybe of how it works, but I will skip directly to the planning. The planning is achieved on the basis of three river basins. Two of them are international, and also the planning has three layers. First, you must have this river basin management plan. Then for each river basin management plan, there has to be a program of measures. And finally, for each program of measures, there is supposed to be a further layer of planning, so-called action plan. Originally, it was foreseen that this program of measures is rather abstract, and then this action plan is something which is much more concrete. At least this is how I understood how I understand the Water Act. The Water Act is not doesn't really say much about these action plans, but the reality is not so good. First, if I speak of the Baltic Sea protection, then I should mention that although the Estonian law more or less reflects the Water Framework Directive, the Marine Strategy Framework Directive, it's not even transposed. Well, actually, there are more implementation measures than transposition measures. So there are some very general provisions in national law, but nothing more specific. And the reason for this is at least partly because the Ministry of Environment has wanted for years to have a specific act on marine protection, but so far has not been able to push one through. What is good about this, the water quality management, the planning, is that there is an extensive stakeholder consultation, both in law and in practice. What is not good is that the water quality planning is not fully implemented, meaning that, for instance, the program of measures do not exist as separate documents. Only the summaries in the water management plan exist. And also, I couldn't access the action plans. I think they exist, and I have access to some drafts, but really not really accessible. And the biggest problem is the formal nature of these plans. The measures are very abstract in nature and not really useful in practical terms. Okay, now just a few conclusions. I won't, because I'm out of time, I'm not reading them, but I just want to sort of end with a positive note that because of the codification of Estonian environmental law, there is at least hope that in the near future the Estonian framework law will be much more closer to this ecosystem-based approach. At least we can hope so. Thank you very much.
So the next part is from the coordinator herself. It's from Annika, who has, of course, been the core in this comparative study, and she will present Swedish law now. The floor is yours, Annika.
Thank you very much. So, as I said earlier, I see my role as coordinating and aligning. Oh, sorry. I was reminded to put on the microphone before, but I forgot it anyway. I will will start by making some comments also about the Swedish report, and then just comparative notes before going into summarizing our observations with regard to ecosystem approach to regulating nutrient emissions in these national systems. Well, Swedish law, then, eutrophication of the marine environment is considered a serious problem in Sweden generally. Sweden is a large contributor to eutrophication of the Baltic Sea, and we have also quite high reduction targets, so Maciej, I don't feel alone in this. But we have had since the 80s, just as Helle described for Denmark, a serious policy about eutrophication control or abatement. And today we have one of the environmental goals of national policy is zero eutrophication. And this goal, it then contains different kinds of underlying goals where we can find those reference to the Water Framework Directive, for example. I will say that this is assessed generally, and the general assessment is that the goal will not be reached. We can see on a regulation then that sewage treatment plants generally we have a good network of municipal sewage treatment plants, largely developed in the 60s and 70s, so then very modern, started to need updating. They are covered, regulated under a permit regime. And as we have heard from the other countries as well. And there are some general standards there are, for these treatment plants, and also recommendations, non-binding norms. Generally, we can see when I started looking at these permits, where they are often quite old permits, and they have quite similar standards. And the general result assessment is that the emissions are fine when it comes to phosphorus emissions, but the nitrogen emissions are more challenging. We also have, when it comes to sewage treatment systems in Sweden, which is a vast country that is scarcely populated, problems with on-site treatment for residential homes and so on. It is said that about, these are a few years old figures, but about 450,000 installations which are connected to the toilets. And this covers about, I think, 1.2 million permanent residents and 1.2 million permanent residents, it said. These figures are a bit old, but still, these are the figures that we have. More crucially, 60% of these installations are assessed not to be up to standard. But we have major enforcement problems. There are a lot of activity here in regulating these, but we have some enforcement problems. When it comes to agriculture, we can see that only the largest farms need permits. We have, as described in the other countries, also a body of very complex and detailed rules on best practices. Many of them are binding rules. And they are stricter in the vulnerable areas. So in a way, that's kind of adaptive to different environmental situations. And then also we have the water management system, of course, is established under the Water Framework Directive. And there has been a lot of work done under this system with classification, monitoring, gathering of data, and building knowledge. And the aim and function, of course, of this system is flexible and adaptive management based on water status. and it involves regulation on classification and quality norms. It can be said that also we have the marine strategy framework. It has been established, but at least when we wrote these reports, it was very early days, so we hadn't really seen much decision-making based on on this marine strategy as of yet. So this is really just a basic description of the Swedish system, and I can then note some comparison on the regulatory systems. And I will note that this comparison is based on the reports, and in some instances the laws have developed. So please feel free, my colleagues, to update and come with comments. First of all, we can see that marine environment, it is central to Swedish environmental policy, and it is lifted up in Danish and to some extent also Polish environmental policies. Marine eutrophication has been said from the Estonian report, has been rather invisible in policy, except for in the BSAP implementation plan with describing measures. But we can see that there is some recognition, at least, or recognition generally in political commitments on marine environment, but not always prioritizing eutrophication as much as, for example, in Sweden. The fulfillment of international obligations are very much made through regulatory measures. And I say this because we have talked about that ecosystem approach, of course, involves different kinds of management measures, not only law. And this is important for us lawyers to remember. But having studied the systems, I would say that comparative observation is that regulation is still very important for implementation and realization of measures to reach these international obligations. And having said that, it's also important to remember what I said in the beginning, that, well, if this is the main implementation method, then law has to function also according to its prerequisites. It has to clearly show what are the norms, who should carry them out, who should realize them, what happens if you don't follow them, and so on. We can see also when it comes to sewage treatment plants, generally there is permit regulation which comes in here. And this means, of course, that you have an individual decision on the allowability, if you're going to allow the installation, and the conditions for the installation to operate. So this is common to all the different nations. Laws, national laws. In agriculture, we can see also that there are comprehensive best practice norms in all the countries, but we see a little differences in how these are implemented and enforced. Permit regulations differ. The largest farms are under permit regulation in all the countries, but for example, I know in Sweden and I think also in Denmark, also we have a permit regulation that is wider than that, so also for smaller farms. Also at the best practice norms in Sweden and also Denmark to a large extent is binding rules. In other instances, they are mostly recommendations. Also, in all the countries, we have the water management system established, and thus an institutional structure for ecosystem-based water management. And we have adopted marine strategies. So, on the surface of it, it looks like our regulations are quite similar in many ways. So, formally, we have the same kinds of instruments to apply and in which to implement the ecosystem approach and to realize the ecosystem-based management. But let's try and look then and search for features of such ecosystem-based management. Well, first of all, searching for the actual word that we started the day with, we can see mentioning of ecosystem approach in some national documents of the Baltic Sea region, but mainly, I would say, on a more strategic level. It's much more seldom clear how it's going to be implemented in the national legal system. My Polish colleague reported that the ecosystem approach was not recognized in the Polish system, and there was some ways to go before it was. But common for all of these systems is really, we have noted that there are aspects of ecosystem approach have, however, been introduced at the most strategic level, and also, importantly, through the structures of the Water Framework Directive. A general observation, having been made in these reports, is that there is room for adaptability in national regulation, in differentiation of general rules, but also in individual regulation. General rules will, for example, be more wide principles that can be applied appropriately to different environmental situations. But they can also be general rules that are differentiated to different environmental circumstances. And we have the example of the vulnerable areas that you have stricter rules, for example, for farming activities in vulnerable areas. These general rules, however, they are so generally formulated, or the general principles, they need to be in some way made operational to be translated into duties, legal duties for individual actors. Another instrument or mechanism that we have all noted has a potential for adaptive and flexible management is permit regulation. We have here individual regulation in the relevant environmental context in the specific site. We have a possibility, a process for wide stakeholder participation. Many procedures also require extensive investigation and knowledge requirements. And there is room for adaptability and flexibility. And these, generally, the permits are also open to review and even revocation. In practice, however, it is noted that this potential for ecosystem approach or for adaptiveness is not fully utilized. Partly because of challenges with regulating precautionary measures. We heard from Kaarel about having to prove the ecosystem, having to prove the problems or the need for stricter rules. But also there are sensitive political matters. In Sweden it's noted for also when it comes to the sewage treatment plants that there is no political support to make the sufficient cuts in either permit conditions or in general rules. And also the fact that this adaptability and flexibility with review and constant updating of permits, as we all know, is very, it's not in practice not utilized. Permits are often very old, and it's a very large process to start reviewing them. Moreover, we have heard about problems with compliance control, that there are systematic problems that the information doesn't reach those who enforce the rules. The water management system then can provide this basis for individual decision making or general rules to have the information base. It can provide a comprehensive and combined approach to have the information to use in these decision making procedures, to have the adaptiveness and flexibility. And this is carried out through plans and action programs, which should be utilized in these decision-making procedures. Because they're not realized, the plans and action programs themselves don't achieve anything when it comes to regulation. It has to be realized through traditional regulatory measures. But what we can see in our critical analysis is that there are, first of all, some uncertainties as to the normative status and responsibilities stated in the water management systems. The plans are usually not binding by themselves, and I'm sorry to say that my example was from Denmark, that there was actually binding rules that had some authority, and also that could support a better normative realization in decision-making procedures. But we have seen the development is that we're going away from that. We can see that when it comes to the objectives, environmental objectives or environmental quality norms, that these are often formulated as goals or more general objectives rather than binding norms, that they are less absolute. And therefore also more difficult to control their compliance with them or to enforce them. And what we can also see when it comes to the plans, that the plans should be then realized through the action programs. However, we have noted that in action programs in different countries, from the report from Estonia, for example, and the Swedish report also, that the action programs are very general and have state very little beyond the obvious, that you should follow the existing regulations, or very, very general obligations. And they only direct very mildly in saying that you should draw up strategies, you should look through, you should prioritize these areas, and so on. And I should mention also that the Swedish action programs for the 5 different water authorities are identical. So I don't see how that can reflect flexible regulation in a water management system. So even though we have the water management system that has this potential for the comprehensive and combined approach for adaptability, we have to make sure that we have structures for implementing them, for actually using them in the legal decision-making procedures. And that involves that you have to have some kind of binding rules. You have to have clarity in what the norms are, who needs to fulfill them, what happens if you don't fulfill them. The Swedish management plans and action programs today are more like guidelines and very generally formulated. And it has been difficult to see in any decisions that these have actually been used in a permit decision or to have actually had effect. I could say just shortly about marine strategies. As I said, they were early days when we did these reports. It's a similar management system. It should be coordinated with the management system, water management system. It has been reported that the coordination is it's said that you should coordinate, but it is very weak. And also we had, I think from the Danish legislation, it said that public authorities must look to it, apply it, but there is no competence to go into existing cases or change anything or kind of put it into action. And in Swedish, Swedish statements has put forward the decision or the position that it is mostly strategical, not very operational. And we have heard also description today that the Marine Strategy Directive is mostly to be seen when it comes to pollution issues to be handled within the Water Framework Directive. And in the Water Framework Directive, the plans, we see very little reference to marine management today. So then we can just ask just a question, can marine spatial planning perhaps support such coordination? I would say today, I can't see it because the marine spatial planning mainly refers to, marine activities and exploitation of the marine areas and not to the control of pollution from land-based sources. But it could be a possible way to develop. But in conclusion, we can see that there are potentials for ecosystem-based regulatory management, also in national systems. We have seen a lot of them. But the key issue is to make ecosystems approach operational. We need to know what the norm is, who is responsible for doing something, what should they do, what happens if they don't do it, and so on. Plans and flexible norms are operationalized through individual regulation. So we need to have clear direction of competences and responsibilities and also compliance control. Comprehensive procedure and regular review is needed for adaptability and flexibility and for substantive stakeholder participation. And these procedures must be given time and resources. And also, water management and marine strategy, it has great potential with this comprehensive info and planning basis, but it needs operationalization. And I can speak for, we can see in the Swedish system, that the first management cycles have mainly been directed at gathering information, building knowledge, and building even more knowledge. So now it's time to put that knowledge into action and actually operationalize it in the legal regulatory system. So, with that, I will say thank you, and I hope for good discussions. And I would also want to take this opportunity before the panel to thank our team, represented here by Maciej and Helle. It has been a privilege to work with you. Thank you.
Thank you so much, Annika. So we have heard now 4 presentations about the implementation of ecosystem-based management. We will have now a final presentation on rather different aspects. In addition to dealing with traditional means of control, permits, supervision, and also the more modern and more recent ways of working with the strategies, with the planning that we've heard a lot about. Another idea that we looked at, and where I will ask Katakmana to come up to the podium, is to see, would it be possible to use market-based incentives? Many, including myself, are worried when we hear calls from Brussels about green growth or blue growth or whatever. We know that these are very catchy words, but it doesn't exclude the possibility that some alternative market-based instruments could be useful to that end. So I asked Katak to come up to the podium, but while he does so, just stand up and sit down again in order to get a little bit moving. It's an order, okay?
Yep. Thanks a lot. Can you see it? Well, yeah.
So, now, please, Katak, I hope you do not ask us to read every little word, but you will guide us through this. Please enlighten us about the legal obstacles or possibilities of looking at a trading scheme for nutrients in the Baltic Sea. Katak.
Thank you. First of all, it is a kind of humbling experience for me to stand up here and explain this issue in front of very successful scientists, social scientists, and jurists. I have prepared it only one slide. I knew that my presentation was the last, and there is always time pressure, and there I feel more time pressure now. So I will try to make it as short as possible. I don't want you to read that. It's a one page, one slide. You know, I think there is some kind of tradition to introduce myself, but I don't want to introduce as a researcher, but some kind of, not because of my background or what, because of my inquisitiveness, I'm interested on those issues. 1992, I wrote a master's thesis on right of landlocked estate access to and from the sea from Stockholm University. 20 years after, I am writing this nutrient trading scheme for the Baltic Sea environmental management. In between that, I did my doctoral thesis and a couple of other climate and energy articles also. But this is something very important, and I feel humbled because the first presentation today by Kaarel Folke was very interesting, although we didn't have much chance to go into details. There were many others. And this terminology, ecological approach, I would rather say ecological integrity. This is the term that we use in many environmental treaties nowadays. This is very important, and I will talk a little bit later if I had a time at the end, but I will immediately go into my presentation. This presentation is based on and made from public international law point of view. And within that, I have also included European laws and even national laws. For example, if a state develops some principles or plan in order to fulfill its international responsibility, that is a part of international law also. So I do not make much differentiation between public international law, European law, or national law. So this is a very important thing. I think that should be a part of sort of new thinking in that respect. The point here is 2 or 3 questions that I have dealt in my presentation. By the way, this is a part of the project. Article is already published, and this is available outside. So even if I am not able to complete my presentation, there will be some chances if somebody is interested to read. 3 questions. 1, why the HELCOM parties failed to fulfill their obligations, especially in terms of reduction of nutrients, phosphorus and nitrogen. Of course, they have fulfilled their responsibility in other areas, but in this area they have failed, number 1. Number 2 question is there any incentive, is there any mechanism developed out of public international law within the past 20 years that can be applied in order to reduce nutrients from the Baltic Sea? This is the second question. And the third question is, like Jonas suggested, can we implement a nutrient trading scheme like the emission trading schemes under the international emission trading or EU ETS also? So these are the 3 questions that I have tried to cover in my presentation and in my paper also. Basically, what I am saying here is, according to the HELCOM Convention, disposal of nutrients and the nitrogen and phosphorus are recognized as a harmful substances. And according to the law of international environmental law and no harm rules, it is not allowed. It is not allowed to dispose harmful substances into the environment if it is a significant harm. And by scientific explanation, eutrophication is a significant harm as far as I understand. This is what the legal stand I'm taking about. That's what I said. I'm not sentimental. I'm trying to be inquisitive. I'm trying to think in a very critical way. This is a harmful substance, and this still continues to be disposed into the Baltic Sea. So this is a legal point of view. Of course, the scientists have provided a great support on that one. It is the scientists, pure scientists, who have said that this is a harmful substance. If it is excessive, to a certain extent it may not be, but if it is excessive, then it is a harmful substance. And eutrophication, it is not the lawyer who have said, it is the scientists have said eutrophication. When there is a eutrophication, there is no life. And this is where I was trying to say myself, when I was born in a country of landlocked state, now I'm talking about law of the sea. And I was doing that. 20 years after, when I went back to my far western part of Nepal, where I was born, I could still see those mountains, but I have never seen those plants that I left as a 10-year-old boy. Those plants are finished. And there is something similar, whether it is a landlocked state or the coastal states. That's why these are very important issues, and harmful substances are prohibited by under international environmental law, and especially under the no harm rules. This is my understanding. And then I have come to this idea that what exists and what should it be done. These are two slides on the same side. What exists today is a lack of comprehensive approach. And many earlier presenters have already said that there is a lack of comprehensive approach. By comprehensive approach, in a layman's term, I would say that we have to unlearn our wrong practices. It is not just enough to say, well, this treaty applies ecological approach. That is not enough. I mean, to make it even more simple, in our traditional understanding and reading, if a small toddler is given a toy of gun, what would that result? And also, if we continue to teach in our kindergarten, the first thing we teach flag, what he or she is going to understand. This is one planet, and we are the one species. This is a very important concept that I would think ecological approach has to adopt. But this is very much lacking. And the second thing, in terms of incentive, why Helle Convention is not fully implemented in terms of nutrient reduction is because it seems that parties feel that there is no incentive. It's everyone's property, nobody's property. Like Aristotle had criticized Plato's philosophy of communism. It's everybody, so in order to preserve and protect this common goodness, common wealth, they feel that there is no incentive. Of course, there should have been an incentive, but in our traditional way of doing things, we see if there are our immediate interests, then we are interested. And this is exactly what happens in public international law also. States, sovereign states, are very much interested to follow the law if it fits their interest. And also, if it doesn't fit their interest, they violate. And that's why, in terms of environmental law, when this is a global public interest, then states have a difficulty to implement this. That's why the question is there any incentive developed in the last 20 years? Can that be developed? Yes, there are some incentive developed, especially in terms of EU emission reduction and also global ozone depletion treaties. Imagine in the 80s, when the treaty was negotiated, it was almost impossible to be negotiated. And then came the ozone fund, and then came the incentive to countries like China, India. They became a part of the system, and now, after 20 years, there is no ozone hole. This is what the scientist says. This was the incentive given to this. Can that kind of incentive is that kind of incentive available within the existing HELCOM mechanism? No. That's why we have to think alternatively. And then also, burden sharing. I have a full solidarity with the Swedish presentation from Poland. Yes, we share the common sea, but our contributions are different. Some are contributing more than others, but there are requirements that the treaty have set. Certain kilo of nitrogen per hectare and phosphorus per hectare also is set according to the conventions guidelines. But this has not been fulfilled yet. Yes, some country might have fulfilled, some of the parties have fulfilled, but not all. That is also another problem. And most important drawbacks or the lacking at the present time within the HELCOM system is the lack of MRV, I would say. Monitoring, verification, monitoring, reporting, and verification. Yes, there are national mechanisms, even in Sweden, there are national mechanisms to be under the different types of directives, including framework directives. You have to, there is a responsibility to collect data, to send the data, but there is no link between the, if I may be wrong, but please help me to correct it. There is no organization within HELCOM which will monitor if the parties have implemented those or not. If the parties had collected those information, is there a verification or not? Even if collected, submitted, there must be some kind of verification. Who is verifying that? And in this context, if there is a strong MRV system, even the soft law, it is possible to implement the soft laws. So this is this. Now the second part, I'll be very short. I know that there is a time limitation and I'll be very short. I think it is possible to use, if we change our approach, it is possible to use nutrient trading scheme based on international emission trading as well as EU emission trading. And more importantly, there is new development in the last couple of years in the energy sector, so-called white certificates. And I think many of you have been noticing that in Germany, the bank is supporting to the individual producer to invest in solar energy. This is one of the successful stories in Germany. So this kind of certificate are possible to be given and to be introduced in the nutrient trading scheme. And Sweden is already planning. I think many of you have, I guess many of you are interested and have already known that Sweden is planning to introduce that kind of certificate-based system by 2015. Hopefully the legislation will be passed, and that has to be implemented by 2020 with certain amount of aim of reducing nutrient, both phosphorus and nitrogen, especially in the area where the basins are located on that area. And another important point to be made is all this has to be done based on the basin approach as well as estuaries approach. By basin approach, I mean transboundary basins. Within the Baltic Sea basin, there are several transboundary water courses, and there are many treaties being concluded regarding those treaties. Except one or two treaties, there is no ecological approach being accepted under those treaties. Yes, there may be many huge number of treaties, rules and regulations, but one has to see whether or not these treaties have adopted those new measures or not. So if we have to be really serious, we have to be able to negotiate those treaties again based on the fact that what kind of load of nutrients they take. And actually they are the one, the rivers and are the one which are so-called arteries and vein of the environment. And that's how they do. That's why in order to implement these two things, one has to take geographical approach of basins as well as estuaries approach of the territorial sea. That's why the pollution from the high sea towards the territorial water and the continental pollution to the sea could be managed. That's the approach. And finally, burden sharing is a very important point. Again, coming to the Poland situation and Russian situation and Swedish situation, for example, in my article I have taken three different examples. And if everyone is not contributing the same, how should they do it? And actually, there is a good principle being developed under the Climate Convention, common but differentiated responsibility and respective capabilities. And that could be applied if we have to apply nutrient trading scheme, burden sharing mechanism can be done. And also, if we also apply EU ETS approach, international emission trading approach, both through the help of CDM and joint implementation mechanism. For example, Swedish bank can introduce water treatment plant in Poland. Then again comes the question of, this is very much near to my heart. When I read, sorry for using the word heart, for my mind I would say, when an economist would say, oh, this is very costly. Costly in what sense? In the long-term perspective or short-term perspective, what kind of economics is that? What kind of economists are those who doesn't see the long-term perspective? Again, this ecological approach and ecological integrity, we all can survive together if we consider ourselves a part of the species, and this is one planet, we are one human being. And these are the legal prerequisites, I would say. I will not go into details, and those who want to discuss, we could have much detailed explanation is given in the paper, but only one thing I would say. If there is a political will among the members of the HELCOM parties, it is possible to implement market mechanism, but personally, I am not very much big fan of market. That's why I will still say that this emission trading mechanism should be introduced not as a substitute of state responsibility, but rather a means to implement the state responsibility. Thank you very much.
So thanks a lot, Katakmala, and I apologize for not introducing you properly before I gave you the floor. Now, we will have a short roundtable with those of you who were involved in the project. So Katak, you can stay here, and I ask Brita, Annika, Maciej, and Helle to come up. Kaarel has left us. We will do a rather short, 5 to 10 minutes completion of this part before we start the final panel. So there should be microphones ready. So, of course, what I think is a common question to all of you is this notion of an ecosystem-based management, is it something achievable? And if it is, what does it mean, really? I mean, you have showed different developments. You have showed that, to some extent, it exists as a term in most, well, in all countries, at least through EU and HELCOM. But what does it mean on the ground? Is it just a catchy word, catchy phrase, or does it really have some impact compared to alternative ways of looking at this? The floor is open to anyone who would like to start. Does this ecosystem-based approach, does it matter for the achievements? What would you say? No, it's not.
Huh? Yeah, I think we have all concluded that it can have, it is important, and it can have an effect, positive effect also through legal instruments. And I think that these management framework initiatives are, as we said, they have a lot of potential. We just have to figure out a way to introduce them also for our purposes in the legal decision-making procedures, and when to also normate who is responsible to do what. There are also other mechanisms that we heard about with the different kinds of management projects with stakeholders and so on. But in the legal perspective, we need to figure out really how to actually direct decision makers to actually put the plans and the information into action. So that's the challenge that we have seen, and the problems that we have pointed out with unclear rules, and if are they binding, who is to enforce them or use them, and so on.
I think that there might be a tendency that it's primarily used as a catchphrase, and in particular in some of the EU documents. I think that something like the Water Framework and the Marine Strategy Framework Directive could be said to represent an ecosystem-based approach, but as long as it just remains with the creating a structure for making plans and being very soft on what should actually be the content of the plans and how it should be put into practice, whether they should be legally binding or not, is a huge discussion, there's very little discussion of that within the EU. So as Annika said, well, it doesn't really matter a lot unless it is put into action, made operational. And in that respect, it's also important to distinguish between ecosystem-based management at different levels, from the policy level to the more specific measures, regulatory measures of actually how to regulate agriculture or wastewater treatment plants, and making sure that this is linked up to the ecosystem needs and objectives.
I think that I agree with your point of view. I think we should not allow the ecosystem approach to become a phrase which is used and repeated in the same way as sustainable development. It can be frustrating when we see that everything what surrounds us is sustainable, but the effect of this sustainability are not sustainable. So it is really very important to give flesh to this body by strengthening the regulation. On the other hand, we all are members of elements of ecosystem, with all everything what we represent, also in some way with the needs to generate some negative impact, and this also has to be included into the full picture.
Okay. Yeah.
Well, I could just agree with what everyone else already said, basically. I think, of course, it's important and achievable, but that also what it means must be researched further from a regulatory perspective, and also it must mean very different things depending on what level of regulation we're talking about.
And isn't it one of the crucial points, the difficulty? Annika, you started. Well, we have done all this. It's just to implement it on the individual, and for me that seems to be one of the main difficulties. How can we, if we use a concept which refers to the system, and that to apply that in specific case seems to be not only just that seems to be the main difficulty. When we heard about the national quotas that was present before, that gives I think a rather clear idea on how we can set reductions in terms of quotas for each country, but then to bring it down to the individual seems again to be very difficult to say that, well, permits or regulations or markets, that we cannot say that one or the other method is more or less ecosystem based. It's more to a form of implementing this. But I wonder, in any of the 4 studies that you have looked at, to what extent have these national quotas been influential? To what extent can they be applied in different plans or specific decisions? The reductions that are set out in the Baltic Sea action plan for each country, have they had any impact when you have looked at the national regulation or the decisions of the authorities? Helle?
Well, not the Baltic quotas. It has not meant a lot in Denmark, but we have had the reduction targets as part of national policy for a long time, and they have been constructed. It has been constructed in a way that, well, we have a reduction target. We have to set the measures, the policy, regulatory measures that we need to achieve this target, and then we put it into legislation. So they have been implemented, and they have also been successful in achieving the reduction targets. The problem is that we don't always see the improvements in the environment. And then we have to continue, and then at some point we reach some limits, regulatory limits for what we can do and how we can achieve it.
I think for the Swedish system, I can't think of that the reduction targets has been actually applied in this specific way. But of course it's important in setting, I mean, we have an implementation plan that has different kinds of measures that should be applied. And of course, the standards on ecological status is very important also for achieving this. But I would say, I don't know if, my impression as a non-natural scientist is that it won't be possible for Sweden to live up to the reduction targets. But please tell me I'm wrong. Yeah. I know I introduced also discussion with some natural scientists, because when I read the documents on the reduction targets, it's also stated that the background emissions from Sweden is half of Swedish emissions. So how do we cut 30%? So
help her, anyone? The floor is open for a few questions and comments now. Here, please, over here. Please present yourself first.
Hello, my name is Hedvig Hopfors and I work at Aquabiota. I've looked at this a little bit on the background levels, and yes, we kind of need to dig it up from land, but instead to reach the target goals, we can dig them up from sea, so we maybe can harvest something in sea that we bring up.
Thank you. Questions and comments? Yes, here in the front.
Thank you. Well, working at the Swedish government, I think I need to give at least a short answer from the Swedish side. So when the Baltic Sea Action Plan was adopted and countries agreed on this scheme of nutrient reductions, it was written that every country should present a national implementation plan, as you mentioned, showing how they would do it. Well, along with the years that followed, some countries presented these plans, some did not very clearly present how they would do it. Sweden tried to show by sector and also initiated some policy reforms to improve, for example, water sector, as was mentioned earlier, through a trading scheme, an idea that is still under discussion, and also within agricultural sector. Well, what happened, of course, was that the Marine Strategy Framework Directive catched up, and the action program within the Marine Strategy Framework Directive is about to be presented in all countries. And that is why I said that the focus and the interesting issue to look into is how countries now, if they bring in the quotas in their discussion on Water Framework Directive and Marine Strategy Framework Directive programs. And what I mentioned was that the Swedish Agency for Marine and Water Management, they have the task to look into how much will the presented actions deal with this quota. And let's see how they present it. But what is important for Sweden is that we actually got a reduction in quota at the last ministerial meeting, which would, our estimate is that for nitrogen, we will make it. Yeah. And we have had a substantial reduction in nitrogen. Phosphorus is much more tricky. We have done a lot in agriculture, and it's very costly and very difficult to do more. But what is the huge challenge here, and I think that is what you mentioned earlier, is the internal load of phosphorus down at the bottom of the Baltic Sea. So even if all countries make huge reductions, we will have this historical depth, an area bigger than Denmark and some other huger than Denmark, which with dead sea bottoms, leaving phosphorus to the system. So a tricky question is, of course, for decision making in HELCOM, how to deal with this phosphorus which is bound to the sea bottom. And that is not really, that is taken into consideration in the quota, but it's not, it needs to be tackled through action in some way. So Sweden has raised that in HELCOM recently. Thank you.
Well, thanks a lot. Now, I suggest we should have a final, I would like to give the final word to you, Annika, who has been now coordinating this project. If you want to say something about outcome of this, anything now before we close this session about what are the main, how would I say that? The most crucial outcome of these comparative studies that you have been engaged with here. Could you wrap it up in a few seconds before we close this session? With microphone, please. Yes.
Well, I think the crucial aspect that we have introduced, that we have started a debate on what does ecosystem approach actually mean in regulation on the grassroots level. I mean, when you go into the individual regulation, and we're not there yet. And as environmental lawyers, it's very easy to just say that's wrong and that's not working and that's wrong. And the next thing is to try to develop what can work. And I would like to end on a positive note and say that we have also all noted potential in legal instruments to introduce ecosystems approach also. So that's a big responsibility for us environmental lawyers to not just complain about the faults, but really try to continue developing these instruments.
I think that was a very good summing up, because I think this is crucial. It's really a way of introducing these terms. So thanks a lot for these endeavors. I hope that your report and your work will be well read. Thanks a lot. You will also be given some